Yes, good evening to all India Bar Examination 17th Court 2023. Welcome, Karibu Sana, to my alternative dispute redressal, including the Arbitration Act multiple choice question. Yes, shall I start? Say yes.
Okay, sir.
Yes, sir.
Okay, sir.
Yes, number one. Yeah. First question. Alternative dispute resolution refer to any means of settling dispute outside of the dash. Option A, court hall. Option B, court premises. Option C, court bench. Option D, courtroom. Shoot the right answer.
B is right answer, sir. Court premises.
Wrong.
Sir, A
Court
court hall.
bench. Court bench, sir.
Wrong.
A court hall.
WRONG, wrong.
D is right answer, sir. Courtroom.
It is a courtroom is the right answer. Courtroom is the right answer. Okay, second question. ADR typically includes early dash. A, neutral valuation. B, neutral assessment. C, neutral appraisal. D, neutral evaluation. Shoot.
D, sir.
D is right answer, sir. Neutral appraisal.
Repeat.
Neutral evaluation. Neutral
D
evaluation.
is right answer, sir. Neutral appraisal.
Wrong. If you say the neutral appraisal, it's a wrong option.
Neutral evaluation, sir.
It is a neutral evaluation is the right answer. That means option D is the right answer. Is it clear?
Yes, sir.
Yes, sir.
Good. Third question. It is in this context that a resolution was approved by the Chief Minister and the Chief Justice of the states in a meeting held in the New Delhi on dash under the chairmanship of the then Prime Minister and governed by the Chief Justice of India. Dash options. A, 2nd December 1993. B, 3rd December 1993. C, 4th December 1993. D, 5th December 1993.
D option is right answer, sir. 50 December 1993.
WRONG. Second option.
Sir, option A, 2nd December 1993.
WRONG.
4th December, sir.
Yes, it's a C. 4th December 1993 is the right answer for the third question. Fourth question. The method of ADR is dash. Find the odd man out. A, neutral evaluation. B, negotiation and conciliation. C, speedy settlement. D, mediation and arbitration. One among them is not relevant to the method of ADR.
C is right answer, sir.
C is the speedy settlement is
Speedy
not there.
settlement.
It is the
Speedy
outcome.
settlement, sir.
It is the outcome of the ADR, but not the method of ADR. ADR is often saves money and speeds settlement. It is the outcome, not the method. Is it clear?
Yes, sir.
Yes, sir.
Yes, sir.
Fifth question. Anyone can unmute and read the fifth question?
Negotiation means self-counseling between the parties to resolve their dispute, but it does not have any dash recognition in India. A, constitutional. B, legal. C, legislative. D, statutory. Negotiation means self-counseling between the parties to resolve their disputes, but it does not have any dash recognition in India. Acha. Okay, sir. Constitutional, legal, legislative, statutory. Negotiation. Constitutional, legal, legislative. Okay, sir. Question is over. You can ask the question, answer from the participants.
And anyone can shoot it. Madam, I am in the online class. I will talk to you later. Yes.
Sir, D is right answer, sir.
D is the right answer. That is the statutory recognition in India is the right answer. 67. Yeah, sorry.
It
7.
does not have the statutory recognition, sir.
Others are wrong options. I
Negotiation.
fabricated it. The sixth question is, in dash, parties play an important role in resolving their own disputes. Option A, negotiation. B, conciliation. C, mediation. D, arbitration.
D is right answer, sir. Mediation.
Negotiation. A.
A is right answer, sir.
Negotiation, sir.
The right answer is mediation. In mediation, parties play an important role in resolving their own disputes. Its answer is
Okay.
C, mediation.
C is right answer.
Yes. The seventh question. What are the methods of alternative dispute resolution in India? Number 1, private judging. 2, find offer arbitration. 3, court annexed ADR. 4, summary jury trial. Here I have given the options. A, 1 plus 2. B, 2 plus 3 plus 4. C, 1 plus 2 plus 3. D, 1 plus 2 plus 3 plus 4.
C is right answer, sir. Sir, 1 plus 2 plus 3.
Okay, sir, correct. Summary jury trial is not there.
Everything is there.
Yes, sir. Yes, sir.
Summary jury trial also.
1 plus
Everything is there.
summary
The
jury
answer
trial
is
is 1. D is right answer. 1 plus 2 plus
D
3.
is the right answer. For instance, you take arbitration, mediation, conciliation, mediation, arbitration, mini trial, private judging. Read. The rest of the other things read.
Final offer arbitration, court annexed ADR, and summary jury trial are only some of the alternative dispute resolution methods available.
So which is the right answer?
D, sir.
D is right answer, sir.
D is the right answer. And the eighth question. What is the most preferred method of ADR? I repeat the question. What is the most
Option
preferred
A is
method
right
of
answer, sir.
ADR?
Negotiation.
Let me finish. I said, let me finish.
Negotiation, sir.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Number 1, A, negotiation. B, conciliation. C, mediation. D, arbitration. Now you shoot.
Mediation, sir.
Mediation is the right
A
answer.
right answer, sir. Negotiate.
No, mediation is the right answer. The best, most preferred method in ADR is mediation is the right answer for the 8th question. Please, if you know it answer, hold it till I spell the last. Then I say shoot. Then you can make it out. So 9th question. Mediation is presently the most popular form of ADR in use by agencies in dash. A, land related disputes. B, family related disputes. C, property related disputes. D, employment related disputes.
D is right answer, sir.
B. Family related.
Disputes.
Shoot.
Option D, sir, employment related disputes.
B. Family related.
The last one, D, is the right answer. Employment related disputes is the right answer for the 9th question. There is a mediation is presently the most popular form of ADR in use by the agencies in employment related disputes. Mediation is the intervention in a dispute or negotiation of an acceptable, impartial and neutral third party who has no decision making authority. 10th question. What do you mean by ADR in India? A, alternative dispute resolution within parentheses. ADR is a technique to resolve the disputes and disagreements between the parties by arriving at an amenable payment through negotiation and discussion. B, Alternative dispute resolution is a technique to resolve the disputes and disagreement among the parties by arriving at an amenable settlement through negotiation and discussion. C. Anyone can unmute and read the C?
Alternative dispute resolution sir. Sir,
Is a technique.
is a technique to resolve disputes and disagreements between the parties by arriving at an amenable settlement through negotiations and discussions.
What is the D?
Alternative dispute resolution ARD is a technique to resolve disputes and disagreements between the parties by arriving at an amenable settlement through negotiations and discussions.
So which is the right answer?
Agreements between
C
the
is the right
parties by
answer.
arriving at settlement through negotiations and sir, C and D say
Yes, which is the right answer?
No, ARD.
disputes and
Alternate
D is
dispute
wrong,
resolution.
ARD, no
ARD
ARD.
in parenthesis.
Acha ARD.
ARD.
Oh, it
Option
is ADR,
C.
sir.
ADR.
C is right, sir.
Yes.
So did you come to a conclusion?
Yeah, C, sir.
C is the right answer, sir.
C is the right answer.
Yes, sir.
See here I have given, in place of settlement I used or mentioned payment in one instead of between, and I used among. Third answer is that C is the right answer. Right. Fourth option, instead of writing about ADR I wrote ARD. So which is the right answer?
C, sir.
Option
C is the right answer. Is it clear?
Yes, sir.
Yes, sir.
Okay. 11th question. Alternative dispute resolution are: number 1, arbitration; number 2, conciliation; number 3, mediation; number 4, lok adalat. Then options are A 1 plus 2, B 1 plus 3, C 1 plus 2 plus 3, D 1 plus 2 plus 3 plus 4. Which one is the right option?
C 1 plus 2 plus 3.
D, sir.
C is
D.
right
D 1
answer,
plus
sir.
2
1
plus 3 is
2
right,
plus
sir.
3.
C is the right answer.
Yes, sir.
D, right answer.
WRO is wrong. Even local other also added in the ADR now. So the right answer is
Yes, sir.
D.
sir.
1 plus
D
D
is
is the right answer.
1 plus 2.
Anyone can unmute and read the 12th question?
Dash of the Civil Procedure Code 1908 renders that relief to the people. If it occurs to a court, there exist facts, facets of settlement outside the court, then court process the terms of the feasible settlement. Option A, Section 86. Option B, Section 87. Option C, Section 88. Option D, Section 89.
Section 89 correct, sir. D.
Yes, sir.
Yes.
Section 89.
Section 89.
Are you sure?
Yes, sir.
Yes.
Sure.
It is the section 89 is the correct answer. Yes. Anyone can unmute and read the 18th question, 13th question?
Sir, repeat the 12th answer, sir. Once again, there is voice breaking is there.
No, the voice is very much clear. Somebody has not, did not mute it, it seems. But voice is very much clear. 13th question, read.
ADR is also established on such important rights under the Constitution of India. 1. Article 14, second option. Article 19, third option. Article 21, fourth option. Article 22A, capital A. A option 1 plus 2, B option 1 plus 3, C option 1 plus 2 plus 3, D option 1 plus 2 plus 3 plus 4.
C 1.
Then which is the right answer? Yes. The right answer. Among A, B, C, D, shoot.
Sir, audio is breakable, sir.
No, it is very much clear. Huh? So the answer is,
Audio is not clear.
Not.
See, I am getting the signals. It is very much clear. Now it is very much clear. So what is the option for the 13th
Voice breaking,
question?
sir.
My audio is not clear, but visible is there, no?
D, sir. D.
Yes, sir.
Run.
C is right answer, sir. 1 plus 2 plus 3.
Run.
Sir, option B, 1 plus 3.
Option B, 1 plus 3 is the right answer. Other thing I concocted. Answer is Article 14 and Article 21. I inserted Article 19 and inserted Article 22, capital A. So the right answer is
B.
Option
1 plus 3. B option.
yes. Fourth question. Anyone can unmute and read the fourth question.
Sir,
14,
screen
sir.
adjustment, sir.
I said anyone can unmute and read the fourth.
ADR's motive to furnish social, economic, and political justice and ADR's motive is furnish social, economic, and political justice and maintain honesty in the community and enshrined in the dash of the Constitution of India. Option A, Article 21. Option B, Article 23. Article 368.
Which is the right option?
Option C, Article 360. Option C, Article 368.
Sir, Article 368.
See, you did not read the preamble.
Yes, sir.
Yes, sir. C is right answer, sir.
D is the right answer. Preamble is the right answer. ADR's motive is to flourish social, economic, and political justice and maintain honesty in the community enshrined in the preamble of the Constitution of India. 15th question.
Yes, sir.
Read. 15th question. Anyone can unmute and read.
ADR also seeks
ADR
to
also
accomplish
seek to accomplish equal justice and free legal aid delivered under dash, referring to directive principle of state policy, in parenthesis DPSP. Option A, Article 39. Option B, Article 39, capital A. Option C, Article 39, capital B. Article 39, capital C.
Option B, sir, Article 39A.
Article 39, capital A is the right answer for the 15th question. Is it clear?
Yes, sir.
Okay, sir.
Yes, sir.
Yes. Now the 16th question I read. Advantage of alternate dispute resolution. Number 1, it is a less costly. Number 2, it is a less time consuming. Number 3, it is closed from technicalities in the case of... See, somebody did not mute it. I am getting the sound. Venkat Reddy, when you speak, you can unmute. When you don't speak, you can mute it. Because you are only the person. Yeah, now you muted. Right. I repeat, advantage of alternate dispute resolution dash. Number 1, it is less costly. Number 2, it is a less time consuming. Number 3, it is a closed from technicalities as in the case of the supervising the cases in law courts. Number 4, the parties are independent to examine the dissimilarity of belief without any suspicion of the divergence of this fact before any law courts. Option A. 1 plus 2.
C is right answer. 1 plus 2 plus 4.
Please, you are speaking. I don't know who is speaking. Ramesh Babu, mute.
Yes, sir.
Ramesh Babu, mute. Yes, thank you very much. Option A, 1 plus 2. Option B, 1 plus 2 plus 3. Option C, 1 plus 2 plus 4. Option D, 1 plus 2 plus 3 plus 4.
Option C
C
is
is
right
right
answer,
answer,
sir.
sir.
Option C.
1 plus 2 plus 3 plus 4.
1 plus
Option
2
D,
plus
sir.
4 only.
1, 2, 3, 4.
1
The
plus 2
right
plus
answer
4
for
only.
this question is C, 1 plus 2 plus 4.
Correct.
1 plus 2 plus 4. Then what is wrong in the third question? Third point, it is closed from technicalities as in the case of the supervising cases in law courts. It is not, it is closed. It is open for the technicalities as in the case of the supervising cases in law courts. Is it clear?
Yes, sir.
Yes, sir.
I made
Sir.
it is closed, but actually it is open from the technicalities. So that is the difference you could find it.
Okay.
Yes. Mute. I will read now. 17th question. In dash, a three-judge bench of the Supreme Court decreed that the Chief Justice decree authorizing the arbitrators in the domestic arbitration and the Chief Justice of India rule in international commercial arbitration shall be deemed to have been made in his administrative capability. In which case law it is decided in this manner. Option A. Sundaram Finance Limited versus NEPC India Limited. B. Konkan Railways Corporation Limited versus Mehul Construction Company. C. Ador Samia Private Limited versus PK Holding Limited and others. And D. All of the above.
Option D, all of the
Is
above.
right answer, sir?
Option B is right answer, sir. Konkan Railway Corporation Limited versus Mehul Construction Company.
It is true. The answer for this question is Konkan Railway Corporation Limited versus Mehul Construction Company. Supplementary question. I don't know whether you know it or not. Where this Konkan Railway place?
Kolkata.
Konkan, Karnataka and Maharashtra.
It is in
border.
Goa.
East.
18th question. ADR being seen as a necessity, felony, popularity out to take the delivery of to all ADR methods along with the negotiation as they are feasible and handy, and it would assist to ease the dash of the courts. Option A, white.
Load of the court.
Option B, let me finish first. Option A, white. Option B, consignment. Option C, load. Option D, burden.
Burden, sir.
D,
Burden, sir. Burden.
It is the burden is the right answer. It is the burden is the right answer. 19th question. Everybody mute. Unless I say shoot, you can unmute. 19th question. The Supreme Court held that an application under Section 11 of the Arbitration and Conciliation Act 1996 shall not be maintainable on account of the provision laid down in the Section 3 capital G and subsection 5 of the National Highway Act 1956, that is NH Act, which provides for the appointment of arbitrated by the central government, in which case law it is decided. Number 1, Tulsi Narayan Garg versus the MP Road Development Authority, Bhopal and others. B. Rashid Raza versus Sadaf Akhtar. C. The Oriental Insurance Company Limited and other versus DC Text Furnishing Limited. D. National Highway Authority of India versus Savidabad Tea Estate.
D. National Highways Authority of India versus Saudabad Tea Estate.
Saidabad Tea Estate. The D is the right answer for the 19th question. Now, anyone can unmute and read the 20th question. Loud
Chief Justice
voice.
of India. The Chief Justice of India's rule in international commercial arbitrations shall be deemed to have been made is administrative capability, and the disconnected party could question the decision under dash of the Arbitration Act for questioning the jurisdiction of the tribunal. Option A, Section 14. Option B, Section 15. Option C, Section 16. Option D, Section 17.
Shoot. Among the ABCD.
Section 14.
Is
Option
right
A.
answer, sir?
If you say section 14, it's the wrong answer.
Section C is right answer, sir.
Section 17, sir.
Section 17, if you say it is a wrong answer.
Section 15, sir.
If you say section 15, it is a wrong answer. So
Section 16.
section 16 is the C is the right answer for the 28th question. 21st question. In dash, the court found that the arbitrator was under the option that he was not expected to disclose the other acceptable facets. A. MS Goyal Construction and Company versus Union of India. B. Goyal Construction Company Private Limited versus ICAI OMPT Commission. C. C.S. Sanjay Dharia, that is Jangi versus 2 SHS Budhiraj. And D. Measures BM Carrier versus Indian Oil Corporation Limited. So, which one is the right option among the A, B, C, D for the 21st question? See the question and see the answer.
Sir, option B, Goel Constructions Company Private Limited versus
ICAIMP within parenthesis T Commission. That is the right answer for the 21st question. Is it clear?
Yes, sir.
Yes, read anyone. Give the chance to the other people to read. 22nd question. Read in a sonorous voice.
in Goel Construction Company Private Limited versus ICAI OMP T, the court found that the arbitrator was under the opinion that he was not expected to disclose the other acceptable facts of the acts dash. Option A, 4th schedule. Option B, 5th schedule. Option C, 6th schedule. Option D, 7th schedule.
Option C, 6th schedule.
Option C is the 6th schedule is the right answer. That the ICAIOMPT commissioner, the court found that the arbitrator was under the opinion that he was not expected to disclose other acceptable facets, F-A-C-E-T-E-S, facets of the acts dash, which is there in the 6th schedule. Okay, 23rd question. The policy of law emerging from the Industrial Dispute Act and its sister enactment is to provide an alternative dispute resolution mechanism to the workman, a mechanism which is speedy, inexpensive, informal, and unencumbered by the plethora of procedural laws and appeals upon appeals and revisions applicable to the civil courts. Indeed, the power of the courts and the tribunals under the Industrial Dispute Act are far more extensive in the sense that they can grant such a relief as they think appropriate in the circumstances for putting an end to an industrial dispute. It is observed in the Supreme Court in one of the case law. A. Municipal Corporation of Kurnool versus A. Padma Reddy and others. B. UP Forest Corporation versus ITATA. C. Rajasthan State Road Transport Corporation versus Krishna Kant. D. Vishakhapatnam Port Trust versus Yellappa Appalanaidu.
Option C, sir.
Option C. Rajasthan State Road Transport Corporation versus Krishna Kant. I don't know how you shooted, but your shooting is exactly the right. Perhaps either you read it or you use my technique. Yeah, here I could not fill the total 24th question. I have forgotten to make it out. I would like to say part 10, section 10, section 15, section 20, 21, but I failed to maintain it. Immediately I went to the 25th question. Okay, doesn't matter. So section 10 leads the number of arbitrators. Okay, now let us see the 25th question. The effect of arbitral and related court proceeding commenced prior to dash under the Arbitration and Conciliation Act of 1996. A. 22nd October 2014. B. 23rd October 2015. C. 23rd October 2014. D. 22nd October 2014. Should doesn't matter even though it is wrong.
23rd October, sir. 2015.
Yes, that is the right answer. 23rd October 2015 is the right answer for the 25th question. Can you tell me what technique that you used it? Sir, your technique I used it. What is the answer?
You
Sir,
are
option
technical.
B, 23rd October 2015.
No, already I gave the answer. B is the right answer. 23rd October 2015 is the right answer for the 25th question. Shall I proceed?
Yes, sir.
Okay, sir.
26th question. A three-member bench of the Honorable Supreme Court comprising of the Honorable Mr. Justice R.F. Nariman, Honorable Justice Suryakant, and Honorable Mr. Justice V. Ramasubramaniam bench has struck down the Section 87 of the Arbitration and Conciliation Act 1996 was being the manifestly arbitrary in the terms of the Article 14 of the Constitution of India, in which case law it is A. Mercuria Energy Trading Private Limited versus Image Mine Product Private Limited. B. Power Mech Projects Limited versus SEPCO Electric Power. C. GVK Power Gaindwala Sahib versus Punjab State Power Corporation. D. Hindustan Construction Company Limited and other versus Union of India and others. Which one is the right option?
Hindustan Corporation Company Limited and others versus Union India and others, sir. Correct
I
answer
don't
D.
know what type of the method you adapted it, but the answer is right. The right answer for the 26th question is D. Hindustan Construction Company Limited and other versus Union of India and others. Now, 27th question. Be ready. Number of arbitrators. Which option is the correct option among the four options? A. The parties are free to determine the number of arbitrators provided that such a number shall not be an odd number. B. The parties are free to determine the number of arbitrators provided that such number shall not be a fractional number. C. The parties are free to determine the number of arbitrators provided that the number shall not be an even number. D. Failing the determination referred to the subsection 1, the arbitral tribunal shall consisting of a mono arbitrator.
Sir,
Same
option
right
C.
answer. The parties are free to determine the number of arbitrators provided that such a number shall not be an even number.
Okay. Only one can read at a time, not two.
C, sir.
The right answer for this 27th question is,
C.
Yes, sir.
Option
if you
C.
say C, is it the C? Correct option.
Yes.
Yes, sir.
Yes,
Yes,
sir.
sir. Should not be
The
even
parties
numbers.
are free to determine the number of arbitrators provided that such number shall not be an even number. So I added an odd number, I added a fractional number. Then what is wrong in the D? Tell me.
Instead of mono, there should be like sole
It is a solo
arbitrator.
arbitrator. It is not a mono arbitrator. It is a solo. Is it clear?
Yes, sir.
Yes, sir.
Yes, sir.
So now, 28th question. The two-member bench of the Honorable Mr. Justice Robinson Foley Norman and Honorable Mr. Justice Vinit Saran bench has struck down a clause which required a 10% pre-deposit of the claim amount prior to the invoking the arbitration proceedings. Option A, Vinod Bhaiyalal Jain versus Wadhwani Parmeshwari Cold Storage Private Limited. B. Mahanagar Telephone Nigam Limited, Canara Bank and others. C. Mrs. Income Tele Limited LTC versus Punjab State Water Supply and Sewage Board. D. Brahmani River Pellets Limited versus Kamachi Industry Limited. Which is the
Option C.
Option C is the right answer. That is Mrs. ICOM Tele LTC versus Punjab State Water Supply and Sewage Board is the right answer for the 28th question. Now 29th question. Relying on the doctrine of competence enshrined in the section 16 of the Arbitration and Conciliation Act 1996 and the legislative intent to restrict the judicial intervention at the pre-reference stage, the Supreme Court held that the issue of limitation would be decided by an arbitrator. So here option A, option B, option C. Option A, Mahanagar Telephone Nigam Private Limited versus Canara Bank and others. B, Vinod Bhai Lal Jain versus Wadhwani Parmeshwari Cold Storage Private Limited. C, Uttarakhand Puri Sainik Kalyan Nigam Limited versus Northern Coal Field Limited. D, Mahanagar Telephone Nigam Limited versus Canara Bank and others.
Option C, sir. Uttarakhand Purv Sainik Kalyan Nigam Limited versus Northern Coalfield Limited.
Yes. Can you tell me how did you know that is the right answer?
A and B options repeated, sir.
Just you can use it. Yeah, it is repeated, but doesn't mean that it is the same answer because other twos are also the equal. Okay, 30th question. What is the section 43 of the Arbitration and Conciliation Act? Power of the court to issue the process for appearance before arbitrator. Which statement is the correct statement? A. The court will issue the same process to the parties and witnesses whom the arbitrator or umpire desire to examine the court may issue in its suits tried before it. B. The court shall issue the some process to the parties and witnesses whom the arbitrator or umpire desire to examine as the court may issue in suits tried before it. C. The court shall issue the same process to the parties and witnesses whom the arbitrator or umpire desires to examine as the court may issue in suits tried before it. And the D is the court shall issue the same process to the parties and witnesses whom the arbitrator or referees desire to examine as the court may issue in the suit tried before it. So here I have given the four options. In the four options, which statement is correct?
D is correct, sir.
Which one?
D for Delhi.
D for Delhi is the correct.
Option B or C, sir. Both look same.
No. Both not look same. See, here I use the ampersand. Ampersand cannot be used in the running language. It should be
Okay.
and. Now you tell me.
C. Option C, sir.
Option C is the right answer. The court shall issue the same process to the parties. Here I put the symbol ampersand, the symbol, but actually in the section it is written equivalent A and D and. Is it clear? In this way also we can confuse you and we'll ask that which one is the right answer. Now just before you say, sir, B and C looks the same. Yes, it looks the same. But in the B I use the ampersand, in the C I use the equivalent. And the equivalent is there in the section 43 of the Arbitration Act. So these are the questions which I prepared today. And I already told you I may not blow my own pipe. You cannot see such a questions in my earlier video. Perhaps there may be combination of one or two is there, but the asking style is different. Asking style is different. Please note the point. So if you happen to see the where it is gone, yeah, and still we do have time ADR. How much the time do you have still? But the now is 10:08. Why 10:08? The time is up. I don't know. Today the Cisco WebEx is kind enough to give the more time. Of course, no. I started late. That is the reason. Okay. If I ask you the supplementary question, what is the ID number of this Act 1996? The arbitration and conciliation ID number means
What ID?
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आह्वान प्रचारित सुनि तव उदार वाणी